The General Data Protection Regulation is fundamentally about creating a higher degree of transparency and confidence between companies and EU citizens by harmonizing rules for the processing of personal data within the EU. Companies are only allowed to collect and store your personal information if they have consent, a valid reason, and a specific purpose. Previously, the penalty for companies that broke the rules were relatively minor. The penalties have now been made significantly stricter to better protect EU citizens. For EU citizens, the introduction of the new rules means that there is now more focus on your rights and also on the ownership of your personal data. This includes the right to be forgotten, the right to data portability, and the right to be informed. To make it a little less complicated, here is an example. If you decide to delete your profile on Facebook, you can then demand that the company ceases to use your personal data for marketing. For companies, on the other hand, it is important that you both know and relate to the new requirements of the Data Protection Regulation. When the new rules are introduced, you, as a company, will have to document a number of things, such as what kind of personal data you process, where the data comes from, and who the data is shared with. And when you collect personal data, you have to provide details of why you're collecting the data, the intended purpose of the collection, and how long it will be stored. The regulation also includes a long list of heightened security requirements that a company needs to be aware of. If these requirements are not complied with in the future, there will be fines of up to 4% of the company's global revenue. In other words, there is a very concrete reason for having a solid overview of the new EU rules for the processing and storing of personal data before May 2018, when the new law comes into force.